At November Tynwald, members pondered when is a dependency not a dependency? Should UK legislation introduced to the Isle of Man by CoMin be laid before Tynwald? And does the Isle of Man need a permanent representative in London? Tanya August Hansen MLC brought the motion forward. You had a very interesting job in Tynwald, in the November Tynwald, and that was to move the first report for the session 23-24 of the Constitutional and Legal Affairs and Justice Committee, and the title the subtitle of the report, The Constitution of the Isle of Man, Internal Self-Government and External Self-Determination. These are big issues, aren't they?
Very, yeah. It took an awful lot of research, and there were a hell of a lot of people that sent in evidence, which was really, really useful, including like some of the political parties on the Isle of Man. We had an advisor to the committee as well, which was Professor Peter Edge. I think a lot of people know of the professor as somewhat of an expert on the Manx Constitution over at Oxford Brookes University. So he's been fantastic, and some of his colleagues like Dr. Derek O'Brien has been brilliant. But we've had quite a bit of contribution from the Labour Party, from the Green Party, from some of the other political movers and shakers, that some of which sit outside, some of them sit inside of Tynwald as well. So yeah, it's been a really fruitful debate, and we kind of all were following the publication of the report on different sides of a fence between CoMin and the committee, and some of the members of Tynwald and some of the contributors, but it sort of seemed to come together reasonably well enough, as well it should. It's consensus, isn't it? It's consensus building.
And one of the surprising things, I think it was the opening paragraph on the very front of the report. It says, since the external constitution of the Isle of Man was last debated in November 2000. I mean, that's almost quarter of a century ago, and nothing has effectively been done of any significance since then.
No, we've just not. So that was the independence report. That was the 2000 report that was debated in Tynwald. It was the 22nd of November in 2000. So yeah, it's been 24 years since it was debated on the round. So it's definitely high time that it was debated again. I think Riatas have also made the point that similarly to ourselves, that that it's been left for too long, because although we have so many different priorities, and there are so many things that can be considered as much more important than reviewing the Constitution, actually it needs to happen a lot more regularly than it has done, and particularly after things like COVID, Brexit, Ukraine, like some of the really big things that we've dealt with, some of them that have affected our borders and our relationships between ourselves and the United Kingdom, and the sort of CTA arrangements as well. It's really important that we do actually have some of these conversations, and especially at times when the Constitution isn't being particularly heavily affected like it was during the COVID period.
And it could actually be argued. I mean, and I know a lot of people say, oh, well, if it ain't broke, don't fix it. Let's focus on the issues like health and housing and all these things. But actually, if we go back to the late 80s, early 90s, one of the ways in which we got out of a particularly difficult financial situation that the Isle of Man was in was by doing some fairly radical changes to the Constitution, because if the system of government keeps delivering the same sort of result, and the result isn't a particularly positive one, then maybe it is time to make some changes.
I think that the ain't broke, don't fix it argument is a little bit tired, actually, and it's simply because the amount of time that you spend as a parliamentarian and as somebody that also works in government, seeing government reactive to things. You want to see proactivity in there, and if they've got time and resource to do it, and Parliament has time and resource to review something like this that is important, alongside all of the other duties and responsibilities that we all have, and myself and David Ashford and Stu Peters, the other members of the committee, they do take quite big roles in government too, as well as myself. So as backbenchers, so it's. I think it's really important that you do actually try and tackle some of this stuff and be very proactive about it at times when it's not being particularly heavily affected, and it's been a really fruitful exercise, I think, because it's going to prompt an awful lot of very interesting conversations between ourselves, the Crown dependencies, Jersey and Guernsey, and then also with Westminster as well. It's been very fruitful debate.
So let's then have a look at some of the recommendations. Now, I know there were various amendments flying around. You've probably got a better handle on what ended up going through. But the first recommendation is that Tynwald is of the opinion that any order in council which extends to the island provisions of any act of the UK Parliament should be laid before Tynwald at the earliest opportunity after it has been made, and that the Standing Orders Committee of Tynwald should consider and report on how such laying might be guaranteed. I mean, that seems like a very an obvious thing to have done. Effectively, what this means in terms of order in council extensions of acts of Parliament in the UK, this is effectively borrowing bits of UK legislation that seem suitable to have in the Isle of Man. And the thought of not laying that before Tynwald at the earliest opportunity after it happens seems a bit bizarre, doesn't it?
Yeah, I think it's the Council of Ministers' intention to do it, but this is a very firm settlement from Tynwald with the Council of Ministers that's the expectation, actually, from Tynwald. And I'm glad that they've accepted it from the CoMin side of the fence, because I think that level of transparency is precisely what we should have. A lot of these things, I mean, I've had the conversation with Riartis as well about, because they were a little bit concerned about, the Council of Ministers' response to it. Even though they accepted it, they were concerned about the commentary that sat within the Council of Ministers' response report. And I said to them, well, if it's being laid before, don't worry about that. It's okay. It's not going to be debated. But actually, Tynwald members can pick that up, because they should be reading all of those things, can pick that up and they can lay it for debate. That isn't something that is, that they're unused to, the idea that happens and that's allowed for in standing orders. So it's the right thing to do, I think, the transparent thing to do. And also it empowers us a little bit more, and particularly on what is and isn't sort of functioning in and around our statute book. I think it's really important.
So effectively, you're doing the bit of psychology here. You start off with something that's very easy for everyone to agree to, and then we move down to some of the other issues. And this one, recommendation 2, Tynwald is of the opinion that legislation made by the UK Parliament at Westminster should not be extended to the Isle of Man without the consent of Tynwald. And that where international issues arise upon which the UK may have a legitimate interest in Manx legislation, the Isle of Man government should continue working constructively with the UK to resolve these by other means. Now, effectively, was it 1967? Was that the telecommunications battle that the Isle of Man
Radio
had?
Caroline.
Yeah, and that was the last time that the Parliament in Westminster legislated for the Isle of Man, and there was a real hoo-ha at the time. A fuss was definitely kicked up about it, because effectively a Parliament at which we have absolutely no representation was making laws for us. Well, you tell me, how did that recommendation go down in Tynwald, and what was government's response?
Government's response was that they accepted it. I mean, it's the current convention anyway that sort of sits in place. But I think a declaratory motion from Tynwald, or recommendation from Tynwald, that Tynwald is of the opinion of, reinstates that, reinforces it, and I think that we need to make sure that we do keep pushing back, because we don't have a written constitution. We have something that's an awful lot more flexible than that, which probably serves us quite well. I think that restating that position, I think that we do need to do that wherever we can, and particularly when we're reviewing the constitutional position of the Isle of Man. I think that it's very important to restate it and make sure that it's firm in the minds of those over in the UK, and that they understand exactly where we're coming from, exactly where we're at. And that is the rhetoric, that is the language that's being used, parliamentarian to parliamentarian, but also government to government, department to department. All of those conversations happen on a regular basis, particularly with the MOJ as well. So yeah, I think it's an important one. But yeah, there was broad consensus across the piece with that.
Because there was a discussion at the very least about beneficial ownership, yes. At which the various UK parliamentarians were sort of issuing veiled threats that perhaps this was one whereby Westminster needed to legislate for the Isle of Man. Of course, the Isle of Man's position in relation to beneficial ownership was we actually had a believable register. Yes, it was it wasn't a public register, but we at least had something that was a sound register. Whereas the UK's register, it might have been more visible, but it probably didn't contain all the detail that our one did. But yeah, at that point, there was a serious consideration that maybe Westminster would legislate for the Isle of Man.
Yes, and also from the backbenches in relation to Margaret Hodge and what was his name again? Oh yes, Andrew Mitchell. That was it. The both of them were quite formidable in trying to legislate for the Isle of Man around the beneficial ownership subject matter, and it definitely put the frighteners up government, and that had to be pushed back on quite vigorously. And they're still talking about it now, because you still see I think it was The Guardian the other day that they published an article that, with those conversations still sort of ongoing. And that sort of leads us quite neatly, I suppose, on to recommendation 3, because that's actually where a lot of the conversation in the committee around beneficial ownership, because David Ashford, MBE, MHK, he was very much involved in those discussions one-to-one with the UK government at the time, because obviously he was I think he was health minister, wasn't he? So he had those conversations CoMin to UK government.
And recommendation 3 basically says that the Isle of Man government and the Isle of Man branch of the Commonwealth Parliamentary Association should seek opportunities to discuss with colleagues at Westminster the possibility of codifying as a matter of Westminster practice and procedure a convention that legislation for the Crown dependencies should not be introduced except on the initiative of the Crown. So that's the initiative of the Crown, not the initiative of the Crown dependencies.
So this was very much, from the committee side of the fence, something that we wanted to discuss with Jersey and Guernsey first before making any attempt to pitch it at Westminster. But essentially, the relationship itself between the Crown dependencies and the UK is with the Crown. It's not with the UK government. It's not with Westminster. It is very much with the Crown. So this is about kind of like, having that conversation around what Margaret Hodge and Andrew Mitchell were attempting to do from the backbenches. It wasn't even coming from the UK government. It was coming from backbench parliamentarians and kind of saying, let's have a conversation around this. Should that be happening? That's kind of dangerous for the Crown dependencies. Please give us, a little bit of respect in our autonomy. And quite frankly, back off.
Well, quite right too. And of course, one of the ways in which you can do these sorts of, or have these sorts of conversations, obviously government has direct government-to-government conversations in the course of their terms in office. And the Tynwald members, of course, have the opportunity to go on Commonwealth Parliamentary Association or two conferences, and often these conferences are just dismissed as, this is just a jolly and a talk and shop and a waste of time. But actually, you do get to meet all kinds of very useful people, useful contacts, which allow you to have these kinds of conversations.
Absolutely correct. I mean, I've always considered the link with the Commonwealth Parliamentary Association. That is where I get my career development from. That's where, I get to talk to other parliamentarians in other jurisdictions about, benchmarking policy. So between, what we do here, or even legislation as well, actually, and what we do here and what others do, it's been actually quite invaluable to have those conversations, especially with Jersey and Guernsey, where essentially a lot of our domestic issues or problems that surface are quite similar. The structure might be slightly different, but as an island nation with a certain, population figures, we have very similar domestic issues. So it's extraordinarily useful. I mean, I worked on, I was very fortunate enough to have been given a parliamentary award from the CPA last year. And that was because I worked on a online educational facility for parliamentarians, because they were spending quite a bit of money on academic institutions and sending people off for training. And, this is how you actually do the job as a parliamentarian. And the academy essentially does that, but online. So it's an online learning facility. So I worked with them to bring that about. Yeah.
And
useful.
Well, it is. I mean, I got to know Ian Gorst, who ultimately became the Chief Minister of Jersey through one of these Commonwealth Parliamentary
An External Relations
Association.
Minister.
Yeah, and then subsequently at the British Irish Council in the summer, Ian Gorst was there, not as a minister, but was there with the Jersey team, and he said, "Oh, what are you doing here?" Because obviously I was there for Manx Radio.
Yeah.
Anyway, then we move on to Tynwald is of the opinion, and I should say up to this stage. So we've got to recommendation. Was that three?
That was three. But
any amendments as yet?
Yes. So that was amended by Mr. Speaker, who is he's very, very interested in the Constitution, very, very interested in Manx history, and reads an awful lot around all of this. He's very interested in the Kilbrandon Report and everything else and how our Constitution was actually brought about. So he came up with 3 recommendations, and the first of those is to recommendation 3, that Tynwald is of the opinion that legislation for the Crown dependencies should not be introduced except on the initiative of the Crown. So it's kind of a declaratory thing. Again, similarly to recommendation 2, it's sort of starting the conversation, essentially, that, do we want Westminster backbench parliamentarians bringing motions that seriously affect the Isle of Man in terms of, legislative change, or do we not?
And that was a successful amendment.
Yes. Yeah. That's so. All of the amendments that were brought by the Speaker were sort of hard fought for amendments that sort of with all of the conversations that in trying to find a consensus position with the Council of Ministers and the committee. So that sort of forms his amendments form a part of that conversation. So all of them were accepted by CoMin. All of them were accepted by the committee.
We'll hear more from Tanya August-Hansen shortly, but first, this is what Russian MHK Speaker Watson, followed by Deputy Chief Minister Jane Poole-Wilson, said in the debate.
I commend the committee for documenting the current constitutional settlement and for looking at further improvements. We've come a long way from emerging from the colonial shadow imposed by the Revestment Act of 1765. And since the late 19th century, we have marched down the path towards independent nationhood. And during that journey, we have always sought the best of both worlds, securing domestic autonomy, maintaining close customs and trading unions with our biggest trading partner, and making our presence felt on the international stage in our own right, while settling for less than sovereign autonomy in return. As such, we have come to a happy compromise, a little short of the precipice of full independent sovereign nationhood, to the satisfaction, I would say, of most in our society. This report is not a big stride down that road, but it is a consolidation with a few baby steps forward based on some threats and opportunities that have arisen over the last quarter of a century since the last review. And I appreciate, with all of the domestic issues facing the government, some of the recommendations in this report will not be top of the agenda. But I would also urge the government to still press for those solutions that we really do want, for that constitutional security which has always been lacking in an unwritten system. In fact, I commend the useful and constructive report of the House of Commons Justice Committee, second report of the session 2023-24, for doing their part to fight the corner of the Crown dependencies and the current constitutional settlement. And I particularly draw the Court's attention to paragraph 71 of that committee report, which talks about the inclusion of a permissive extent clause in the United Kingdom Fisheries Bill without consultation and without a request from the Crown dependency governments. The fact that they call it extremely regrettable and contrary to the constitutional relationship shows that, reassuringly, our situation is understood beyond these shores, and that the ongoing work which we all do in this court in educating and informing UK parliamentarians on that constitutional relationship is not only not wasted, but has been invaluable over the years. It underscores the ongoing and increased efforts that need to be made in this area, especially in the light of the significant churn of MPs in Westminster this summer. For this reason, I don't agree with the government's amendment to recommendation 4, which seeks to kick the can of a London office down the road even further. In the absence of any other resourced engagement strategy, ideally by both government and Parliament, we need some way of ensuring that this ongoing education continues to happen at all levels and across all parties in Westminster. I'm also happy to accept recommendation 1, and I'm sure that my colleagues on the Standing Orders Committee will enjoy the prospect of yet another angle of inquiry to add to our labours, which I assure honourable members is a labour of love. We are definitely in need of a better way of controlling and recording UK legislation entering our statute book, and I refer the honourable members to the question which I asked in the House of Keys on the 8th of December 2009, which, as far as I can tell, is still the only attempt that's been made to capture all the UK legislation which has been extended to the island. Likewise, recommendation 2 reflects both the established practice and the reflections of the Commons Justice Committee report, and like the government, I too support the recommendation. Recommendation 3 is more tricky, and I completely understand the concerns of the government in wishing to try and impose our will on another parliament. There would be an air of hypocrisy in our government trying to do to Westminster what we have always spent so long discouraging Westminster from trying to do to us. However, I do believe that more could be done to counter the threat of inappropriate legislation finding its way through populist channels to impact our island. So I'd like to propose the following amendment, which is to replace the words between the Isle of Man government and a convention that with Tynwald is of the opinion that. This makes the recommendation a declaratory resolution of Tynwald, but does not impose a duty on government to pursue it. It is, however, quite legitimate for individual parliamentarians to pursue this angle on behalf of the Manx people, and I, for one, would like some mandate from this court to pick this thread up with the Speaker of the House of Commons when we next meet. I likewise have sympathy with the government prioritisation of recommendations 5 and 6, which, although important, are not necessarily urgent. Recommendation 7 is a curious one, and the convening of the Consolidation Board under the Legislation Act is a matter for members of that board, and the government is not particularly involved in that. Again, I accept this is not going to be the top of anyone's priority list, but the Consolidation Board was inserted into the Legislation Act in order to start tidying up the statute book, and it has not yet been used. I'm also struggling with government's amendment to recommendation 8, more specifically the rationale behind that amendment, so hence what's coming forward. So I can see that some of the other recommendations in this report, restyling the Crown dependencies, is definitely not top of the list. But I do take objection to the assertion in government's response that we are dependent on the UK. In the modern constitutional era, that we have chosen to contract with the UK on the issues of defence and common purposes, which is in our mutual interests, including diplomatic representation around the world. I draw a distinction between that and, say, compliance with international treaties, where the UK is, as a matter of law, responsible for the Isle of Man. However, I don't accept that that makes us dependent. Dealing with this recommendation would be far easier if I had the killer phrase to replace Crown dependencies with, and sadly, I don't. I would, however, recommend it as a work stream in the next meeting of the Crown Dependencies Network, which is a forum for parliamentarians to consider matters of mutual interest. And I hope that some further suggestions will emerge from that, which perhaps could be brought back to our respective legislatures for further consideration. So again, with Recommendation 8, I seek to test the water with Tynwald as to whether they share the sentiment without necessarily taking the large leap of faith in time or committing government to action. So I propose to delete all the words after Isle of Man to the end of the paragraph, making this again a declaratory resolution at this time. And reading the report, I think this does reflect the committee's sentiments. Our island's constitutional development is a fascinating subject, which I've been studying on and off for the last quarter of a century. In fact, my undergraduate dissertation was on this very subject, which wasn't easy trying to wangle that into a management degree. I shall therefore at this stage attempt to curtail my enthusiasm and passion for this subject, which I'm sure many of us could talk at for a long, long time. I restrict my comments to the report and the amendments. I thank the committee for their work and beg to move the amendments standing in my name.
The committee has done excellent work in its report and in looking at this issue. And I think one of the challenges probably for us all is we spend much of our time in this honourable court debating the things that really matter day to day to people's lives, the constituents we represent, which is absolutely as it should be. I think the committee's point that we shouldn't forget, though, our constitution and to nurture and support its ongoing effectiveness and development is a valid point. I think the challenge, though, for us is understanding and appreciating how we might best do that. And it seems to me, certainly from my experience now, having been a parliamentarian as a member of Legislative Council, but also now as a minister representing the government, that there are many, many ways in which we do actively facilitate better understanding and appreciation of our constitutional relationship. And I've had that privilege, which I recognise honourable members may not see all of the time, but I've had that privilege of engaging directly with ministers, with shadow members of Parliament, with the members of the Justice Committee, the House of Commons Justice Committee, who, to their great credit, did take the time to really speak to people in the Isle of Man and the other Crown dependencies in preparing their report that they took forward in Westminster. And I think that work is, as the Chief Minister has alluded to, making a difference in practice to an understanding of our constitutional relationship, but we must continue it. The reference has been made to the huge change in the representation in the House of Commons, and so our efforts must always continue. But to the amendments, I think we should be sensitive and thoughtful about how we progress continued work on upholding and supporting and promoting our rights and position as an island. And I think on, for example, Recommendation 3, to be clear, there is support for Mr Speaker's amendment because the committee, I think, too, has recognised that codifying, which was the language in the original recommendation, is not apt in this instance. And also to understand that there is, I think, as Mr Speaker put it, some level of hypocrisy in a government of this island seeking to impose its will on another parliament. So another route to try and continue engagement on these issues, I think, is the right way to go. And I'm pleased that the committee were able to engage on that point. Similarly, Recommendation 4, I think everybody would agree that it matters enormously that we do engage in Westminster and more widely in London. Again, what's the appropriate mechanism balancing our financial and other resource with the outcomes we are trying to achieve, and hence the Council of Ministers amendment to Recommendation 4. Just to be clear as well, I think when the Chief Minister was making his remarks, the Council of Ministers is able to support the amendments brought forward by Mr Speaker to Recommendations 7 and 8. And I think, again, this issue around what's in a name, yes, we could debate it. I think it leaves it there for people to continue to have that dialogue whilst recognising that in our overall priority set, perhaps it isn't the thing that we ought to be directing resource to, government resource anyway, at this particular point.
That was Speaker of the House of Keys, Juan Watterson, followed by Deputy Chief Minister Jane Poole-Wilson. Back now to Tanya August-Hanson. And then we move to Recommendation 4, that Tynwald is of the opinion that the island needs to deploy a permanent representative to Westminster who is accountable to the democratically elected government of the Isle of Man and that Tynwald calls on the Council of Ministers to investigate how this opinion could be put into practice and to report to Tynwald with recommendations, and further, that as part of its investigation, Council of Ministers should explore the possibilities of sharing expertise and resources with Jersey and Guernsey.
Well, I think that the nervousness around all of this was how much it would cost, essentially. My response to that is it could be a civil servant that already works actually in external relations that could be doing that. They don't necessarily have to be based in Westminster full time. They could be based part time.
And we did have one in Brussels, didn't we?
We still have a part time person sitting over in the Brussels office, but not in Westminster, where we do most of our sort of most of those conversations tend to happen in and around Westminster. So it doesn't seem to make any sense. Jersey have found it very, very, very useful to have the office there for both backbenchers and also for their council ministers as well, because you've got sort of a bunch of individuals. I mean, you have this churn that goes on all of the time between people that are responsible politically for various different things, and then people that are responsible as civil servants in departments across the UK government. And actually, you want to be able to sort of, when you go over there, have a brief. This is, these are the people that you need to speak to. This has changed last week, the week before that. But, these are the people that you need to speak to right now about this issue. Off you go. It's very, very useful. We have these conversations, departments to UK government departments all the time. So DEFRA, say, for example, I'm in there as a political member responsible for legislation. We will have conversations around fisheries, around various different regulations that we share and common purpose with. You'll have a lot of conversations with DEFRA over there and the various different other connected agencies too. And that churn that takes place, a lot of those individuals, they don't know what the Crown dependencies are, what the autonomy is.
So I'm guessing this person that you're talking about, the permanent representative, would be continually badgering the various parts of UK government that we have the most dealings with, just to remind them, you do realise this is how the actual constitutional relationship works. I'm
sure you remember Della Fletcher.
Yeah,
who
absolutely.
was the absolute. She was a brilliant external relations director for the Isle of Man government, and she knew everybody. She knew when they'd all changed. She knew all of the politicians that people needed to speak to. When was the most appropriate time to talk to them? What the context was around those conversations that needed to be had. What the update was to any of those given situations. She was fantastic. And we've not had months and months and months we've gone without an external relations director, and now we've got one. And it's within the last week or so, 2 weeks.
You mentioned about Tynwald focused a bit on the cost of all this, but of course the other way of looking at this, in this instance, having someone who is there to be able to keep an eye on things and make sure that things don't go off in all sorts of bizarre directions, could potentially save us money and maybe make sure that the Isle of Man is better placed to grasp opportunities that may arise.
Yeah, I don't think that we should be shortchanging ourselves, that's for sure. But I think there was a lot of conversation around Jersey and Guernsey as well, and whether or not we should be sharing an office with Jersey and Guernsey. Jersey and Guernsey are considering sharing an office together at the moment, and the conversations around the Crown Dependencies Network events that we do every single year. We have like one event, sort of like a 3-day event every single year around September, and it alternates between Jersey, Guernsey and the Isle of Man, and Alderney as well in one case. But we all seem to have the same conversation time and time again. Oh, well, why don't we actually, we can have our own sort of separateness, but why aren't we sort of sharing resources in this particular area? It doesn't make sense. It's very expensive. So why not sort of share that cost?
And I'm guessing part of the reason why not is because whilst in most cases we have common interests, we are also in certain instances, competitors.
Yes.
And I'm guessing that's part of the concern that would have been raised. So what did this this recommendation get amended in some form? Or
No.
Right. Okay. So again, government were content, and
oh no, they were not happy with this. Well, they amended it in a sort of a very, very kind, very soft sort of, oh, well, we'll have a think about that. Thank you.
Right.
Which is fine. And I understand why they're saying it, because essentially, it's just not a priority for them. They have a lot of other government priorities that sit on either, in the island plan or, some of the very serious issues that we've got at the moment. And I get that. I understand that. But I do also think that this is important too. And we're still waiting as well for our external relations strategic report, which we still don't have, which was in, I think, the Cabinet Office plan at the start of the administration. So still waiting for that to happen.
Move down then to the next, and this is something I know a lot about because I was part of the committee back in 2011. So recommendations made within the Transfer of Governors Functions Report 2011 should be expedited and implemented as soon as possible. Yeah. Now, this was a committee that I think it was a committee of Council of Ministers. Certainly, I remember Tony Brown. I was involved. I think Dewan might have been involved, or maybe not.
No.
But
he wasn't there at the time.
Right. Well, anyway, whoever was there, the recommendations were made, and this was basically trying to tidy up the position, because, of course, the governor, if we go back far enough, had complete control over pretty much everything on the Isle of Man, and then gradually over years this was diminished. And this was a tidying up exercise back in 2011, pointing out that there were certain functions that still were carried out by the governor, but probably bearing in mind that all the changes that had gone on before, maybe it was time to actually remove these remaining functions, which would be better performed by government.
Yeah, I think that the sort of when I was talking about in the speech that I gave in Tynwald, when I was talking about the Constitution, half of that was very much about the sort of external stuff, which is some of the things that perhaps we've just been talking about. And then the other half was very much about the internal Constitution. There is nothing fundamentally wrong with it. That certainly that we could find, but there isn't anything fundamentally wrong with it. We think it works reasonably well. But those two recommendations, 5 and 6.
Yeah. So let's look at 6 as well. That a review should be undertaken of the non-statutory power of the governor, and consideration should be given to which of these ought to be transferred to the Council of Ministers or elsewhere.
Yeah, so those two together, I think, are very much about sort of the Lieutenant Governor's position, where it historically has been, and sort of the change of where that power sits between where he is and where the House of Keys are, where it should be. So the suggestions made in a lot of the transfer of function stuff is legislative, statutory. Things like, so for example, and this is probably quite an important example, is where we had the declaration of the emergency and the need for emergency powers from the Lieutenant Governor. So we had to go to the Lieutenant Governor and ask for those. So Council of Ministers, the Chief Minister at the time, Howard Quayle, went to the Lieutenant Governor and said, "Please, sir, may I have these powers that I desperately need, actually, because there's a worldwide pandemic, this big crisis that's on the horizon that I need to deal with." And the question is, should he have had to do that?
Bearing in mind we are in all other senses a fully functioning democracy, you do wonder why an appointee of the Crown would have control over things as important as emergency powers.
Yeah, and it's that would have been absolutely, it's okay. It's a convention. It's a statutory convention. But you're going to somebody, and in the legal space. So in the words of the emergency powers legislation, we had that it had to be put into the hands of the Lieutenant Governor himself. So it couldn't be delegated individual. So say, for example, this horrible case where, the hypothetical case, by the way, but this horrible case where the Lieutenant Governor is not available because, he might be in the hospital, or he might be just incapacitated, or for whatever reason he's not available. That wouldn't have been able to happen technically under the legislation that then sits in, because it needed to be put into his hands.
Yeah.
And because of the wording of the legislation.
You can imagine all manner of crises where emergency powers might be needed, where, anything could happen, some geographical or disaster where, a landslip or whatever it might be, and the governor was affected by it, and then nothing.
We can't do it because
nothing
not put
can
it
be
into his
done.
hands.
Yeah. And those two recommendations, were there any amendments to those? Or
so essentially, I had to listen to what the Attorney General had to say. So he spoke actually in the debate as well. And he said, look, we've started looking into this because you've highlighted it as a concern. We are seeing essentially that the 2011 report, that there are some things that aren't in it that need to be. The legislative list, that there are some things that are in it that just don't work quite the way that we want it to. We need to investigate it further. And there are some things that we've already done over the years. So we need to basically kind of come up with a report that sort of covers all of those different things, and then sort of bring a list of those that we can change, and put them to the drafters to make those alterations. So they're committing to doing it, but it's just a case of priority. And again, it's priority. So again, I understand. I completely get it. If they've got time to do it, they have the space to do it with something like a statute law revision piece of legislation, which tends to come like once or twice in an administration anyway. It's just a tidying up exercise, and this is just a tidy up exercise. So it sort of makes sense that you put the two together. I accepted both. We accepted both recommendations there. The non-statutory functions in recommendation 6. I mean, I'm not entirely sure that the Lieutenant Governor knows what all of his non-statutory functions are. Bless him. I don't want to put words into his mouth, but I don't think that he does. So it's a case of figuring out what those are. I think we've had examples quite recently of the captain of the herring fleet, Dr. David Beard, being given that title, and that was something for a number of a couple of 100 years, had not been given before for some considerable period of time. Something that His Excellency found and sort of said, right, okay,
and
I'll
it's
reinvigorate
a great thing to have done.
Yeah, it's lovely.
And then the final two recommendations that we move to, the constitutional statutes of the Isle of Man should be consolidated into one Act of Tynwald, and that to that end, the President of Tynwald should convene the Consolidation Board established by Part 6 of the Legislation Act 2015. So in effect, that's kind of comes out as well. Well, it takes some of the work of recommendations 5 and 6 and then carries it all out in recommendation 7. And the reason that you'd stated for doing this was it just makes it an awful lot easier for everyone to know that there is one bill that they would need to go to find out what the legislation surrounding the Constitution of the Isle of Man is.
Yeah, and that's a Tynwald practice as well. So the amendment that came from the Council of Ministers was kind of like, oh, well, we don't have time to do this. We've got a very big legislative programme. It's yes, that's fine. They seem to think that it was on their legislative programme. It's no, it's not. Actually, it's a Tynwald thing. It's a Tynwald committee thing. It's something that we can do alongside many, many other different things that we already do, either in Tynwald or in government. And the Consolidation Board would be brought by the President of Tynwald. So he would be the one that's responsible for the drafting instructions for those going in and the drafter being appointed. All of that will take a considerable period of time. Consolidating something quite so big as a number of different acts of Tynwald, where all of these different bits of constitution sort of sit. Your average person should be able to pick up any piece of legislation and be able to understand it. And not only that, but they shouldn't have to search right the way across the statute book to try and find or bring everything together. They should be able to pick up their legislation, read it, and it be accessible to them. And I don't think that that's the position that we currently sit in with something quite so important as this.
Well, I can absolutely say that is the case, that it's all over the place. Having sat on that Transfer of Governors Functions Committee, subcommittee of Council of Ministers, which produced the 2011 report, there were bits of legislation all over the place, and it took a bit of finding out. And then the final recommendation, and this is one that it certainly grigs me, is the Tynwald is of the opinion that the word dependency does not reflect clearly the constitutional status of the Isle of Man, and that Tynwald calls on the Isle of Man government to engage in discussions with the Manx public and with the governments of the Channel Islands and the UK with the aim of finding a better term. And Crown dependencies, compared with the other set of nations, the overseas territories. Overseas territories is quite a descriptive term for what they are. They are overseas territories associated with the United Kingdom. But Crown dependencies makes it sound as though every year the King dips into his back pocket and hands us over a load of cash. Well, maybe he should, but that doesn't happen. And I'm guessing I've just explained why you want to at least consider this.
Yeah, well, I know that. See, this is another one of those things. Like, a lot of people saw this now. Oh, for goodness sake, parliamentarians going off and having conversations about all of these things when there are more important things to deal with. And again, I agree with that. And they're right. But this is something that came about 50 years ago. So it's not something that is actually it came off the back of, I think the Kilbrandon report was the first time that it was mentioned. And that was in the 70s. So it's recent.
And actually, it probably
wouldn't
be that big a deal to actually alter it. It's a name, so everything that has had the name Crown dependency in it, presumably over years, that term would have to be changed to a different term. But you can introduce a single piece of legislation, whether that be in Westminster or the Isle of Man, or indeed both, which says for everything that we used to say Crown dependency for, we now say, I don't know, Crown territory or whatever it might be.
There have been so many suggestions, particularly from Jersey and Guernsey parliamentarians. Everybody seemed to sort of like the Crown bit, but the dependency bit, that was where the cringe kind of came in, because it's just not accurately reflecting the situation.
And it is misleading then, because it also, presumably, anyone who is considering establishing businesses, whether that be in Jersey, Guernsey or in the Isle of Man, and they see that term dependency, they may well think to themselves, well, does that mean, therefore, that the Crown has a lot of say over the Isle of Man, perhaps more say over the Isle of Man than it does over the overseas territories, which don't describe themselves as dependencies? And actually, the opposite is the case. We've got more control than the overseas territories have.
We do. We're in kind of an enviable position, actually, by comparison to some of our Commonwealth neighbours. And you find that out quite quickly, actually, from some of that association around the Crown dependencies. Relationships with the Commonwealth Parliamentary Association, because a lot of the individuals that you end up mixing with, like, oh, really? You're able to do that? You're joking. Like, oh, God, we'd love to be able to do that, but we can't because of the way that we're set up. So it's, that becomes quite apparent when you start having those conversations, that we're in a much more autonomous position than some of the OTs are, definitely.
So that recommendation 7 and 8, were those two
yes.
Accepted without amendment, or no?
I and certainly my committee members as well, the three of us weren't very happy with recommendation 7 and the way that had been amended, because it made the assumption, like I said earlier, of oh, it's on the legislative programme, and you're talking about it in relation to this administration. No. And also, it's not government, it's Parliament, so back off again. Another back off, but from our side of the fence. It was amended, with recommendation 7, which thankfully CoMin were very much in support of, because they understood the point. that the constitutional statutes of the Isle of Man should be consolidated into one Act of Tynwald when it's practicable to do so. Absolutely fine with that. I think that they had like an extra little bit on there about it being part of their programme when it just isn't, because that would sit with Tynwald. But the recommendation 8 was that Tynwald is of the opinion that the word dependency does not reflect clearly the constitutional status of the Isle of Man, which I personally believe it does not.
And was that voted out, amended out?
No, it was agreed to.
That was agreed.
By CoMin, yeah.
Well, there we go. And yes, quite revolutionary. So what are you going to do in the next 2 years? Are you going to declare UDI? Tanya August Hansen, MLC there. So what do you think? Is this a case of fiddling while Rome burns? A much-needed attempt to fix our outdated constitutional relationship? I guess most people will agree that we're not really a dependency, but try getting everyone to agree on what name should be used instead. And what about a permanent representative in Westminster? Let me know your thoughts on the programme by contacting Phil Gorn at manxradio.com and get in touch if you have any ideas for future shows. Don't forget this programme is available as a podcast on Manx Radio's website. I'm Phil Gorn. Go to Myers and Geistakrom. Thanks for listening.